You may be seated.
We can proceed.
Mr. Court pleases, today is the 26th of September 2025 in the Magistrates Court sitting at JP Karwai Street.
Just a minute, you can count. We are not using the number, right? Yeah, okay, that's fine. Yeah. Okay, you can proceed.
Today is the 26th of September 2025 in the Magistrates Court sitting at JP Karwai Street, case number 845 of 2025 in the matter between Emmanuel Mulunga and 14 others. Presiding officer, Mr. Samunza, for the state, Mili Lungwe, for the first and the second applicant is represented by Mr. Namanje. However, Mr. Gaib is standing in for him. For the third and the fourth applicant, Mr. Bangamavo and Mr. Laya is standing in for Mr. Bangamavo. For the fifth applicant, Mr. Kasper appears for the applicant. However, Mr. Gaib is standing in. For the sixth applicant, Ms. Gebhardt, and Mr. Gaib is standing in for Ms. Gebhardt. And the matter is before this court for judgment, and we are ready to receive the judgment. The court pleases.
As court pleases, Your Worship, I confirm appearance for applicant 1 and 2, as well as standing in for Mr. Kasper and Ms. Gebhardt, who are unavailable but extend their apologies to the court. We are ready to note judgment, Your Worship.
May it please the court, I am Mr. Laya, representing the third and fourth applicant in this matter. We are ready to note judgment.
Yes, the court will proceed and read the judgment into the record the next about 2 hours. Introduction. Section 60 in bracket 1 of the Criminal Procedure Act 51 of 1977 in brackets Act 51 of 1977 as amended states that any accused who is in custody in respect of any offense may at his or her first appearance in a lower court or at any stage after such appearance apply to such court to be released on bail in respect of such offense, and any such court may release the accused on bail in respect such offense on condition that the accused deposits with the clerk of court as the case may be, or in the official or with the official in charge of the correctional facility where the accused is in custody, or with the official in charge of the correctional facility where the accused is in custody, or with any police official at the police station the accused is in custody. The sum of money determined by the court in question. Therefore, an accused who is in custody has the right to apply for bail, but this falls short of entitlement to bail. Bail can therefore not be claimed as of right. Hence the need for its application and to establish that the applicant is a candidate worthy of being granted bail. Serving before this court are opposed applications for bail. The applicants are charged of numerous counts, among others fraud, theft, alternatively theft under false pretenses, money laundering in contravention of the Prevention of Organized Crime Act 29 of 2004 in brackets poker, conspiracies, corruptly accepting gratification or giving gratification to an agent, dealing, using, holding, receiving and concealing, as well as corruptly using office or position for gratification in contravention of sections of the Anti-Corruption Act 8 of 2003. For the full charges, see the charge sheet. The applicants appear in the case that has become known as Fuelrot. Mr. Namanje, assisted by Mr. Gayeb and Mr. Kaldondana, appeared on behalf of the first, second, and third applicants, as well as accused 10. Mr. Bangabwabwa appeared on behalf of the fourth and fifth applicants. Mr. Casper and Mrs. Gebhardt appeared on behalf of the sixth and seventh applicants, respectively. The respondents, in bracket the state, is represented by Advocate Lilungwe, herein after referred to as Mr. Lilungwe. The applicants will be referred to as first to seventh applicants individually or collectively as the applicants for purposes of these proceedings. The first to fifth applicants brought their bail applications viva voce, whereas the sixth and seventh applicants brought their applications by way of affidavit. Mr. Obeti Inambao will be referred to as the investigating officer for purposes of these proceedings. Further, Enecon Pty Ltd and the Ministry of Defense will be referred to as Enecon and MOD respectively. The National Petroleum Corporation of Namibia as NAMCO, whereas NAMCO Petroleum Trading and Distribution Pty Limited will be referred to as NAMCO Trading. Enecon and NAMCO Trading will be referred to as such individually or collectively as the parties. The Anti-Corruption Commission and the Anti-Corruption Act number 8 of 2003 as the ACC and ACC Act respectively. Further, Enecon bank account number 800 3510848 and number 8023531520 will be referred to as bank accounts number 848 and number 520 respectively. The following factors are common cause and not in dispute. Both applicants are Namibian citizens. The first and second applicants are brothers, business partners, and directors of Enecon. The third applicant is the wife of the second applicant, and she was already granted bail with conditions. As such, this court will not deal with her evidence for purposes of these proceedings. The parties entered into an asset purchase agreement in brackets APA. The first and second applicants signed the APA on 15 July 2022 as directors of Enecon. And the fourth applicant signed on 18 July 2022 representing NAMCO Trading. NAMCO Trading paid 53,212,000 Namibian dollars, or in short 53.2 million in two parts, 35 million and 18.2 million on 18 July 2022. To Enecon, 35 million was paid back, 35 million was paid to Enecon bank account number 520, and subsequently it was paid back to NAMCO Trading in terms of the agreement in partial fulfillment of Enecon's debt. 18.2 million was paid to Enecon bank account number 848, and subsequently 3,613,000 and 9.5 million of that amount was paid to Onyeka CC and Eco Trading, respectively on the even date. Further subsequent payments were made from Eco Trading CC to various business entities and accused two in particular, the following amounts were paid. 1 million to Venus Trading, 1,470,000 Namibian dollars to Quality Meat CC on the event date. In turn, Quality Meat CC made several payments to other persons and business entities, including 960,000 Namibian dollars to accused 2 personal Standard Bank account number and 500,000 Namibian dollars to Panduleni CC, which is owned by accused 8, the husband of the 5th applicant. Onyeka CC paid the first and second applicants 1.5 million Namibian dollars each on the event date. Venus CC paid the 6th applicant 10,000 Namibian dollars on 4 August 2022. The 4th applicant was the managing director in brackets MD of both Namco and Namco Trading at the time. The 5th applicant had signatory rights to Enecon bank account number 520. Further, the 5th applicant and the 8th accused are married to each other, and the former has signatory rights to Panduleni CC as well. The 5th applicant was employed by Namco as the executive for finance and administration, whereas the 6th applicant and accused 8 were employed by Namco Trading at the time. Accused 8 withdrew his bail application. I must indicate from the onset that underlined in this judgment is my emphasis. Summary of the evidence. The first applicant testified that he is a Namibian born in Oshikoto region. He resides at number 1500 L595 Hammerscockville, Hockland Park window. The court asked him, did he say number 15? He testified no. 1500. It is not an F, but the outside number. Mr. Namanje stated that the same property where he lives, the street number is 15, but the F in bracket F number is 595. He confirmed so. Exhibit 8 contains his personal information and reflects his residence as number 15, Hammerskralve, Hockland Park window. He is a freedom fighter and a lawyer by profession. He was arrested on 9 July 2025. He was informed that the state was looking for him, and he went to cancel of record. They drove to ACC and he was arrested. He did not run away, and he was aware about the investigation since 2020. Since 2022. He cannot run away because he has business interests, a house and employees. He is not afraid of the case because it is a commercial transaction. He wants to clear his name and will go nowhere. He is self-employed, operating a number of businesses, married with 4 children. He has an ordinary passport and it is with his cancel of record. He does not have a problem if the same is provided to the respondent. He owns properties with a total value of 118.2 million Namibian dollars. His liabilities are 27.3 million with a net asset of 90.9 million. With regard to the charges, the first applicant testified as follows. Count 34 relates to Enecon and not him personally. He was a shareholder and director of Enecon. First, there was a discussion or engagement between him as chairperson of Enecon and accused number 1, in bracket the 4th applicant, subject to Namco Trading approval, and he does, in brackets, did not check for internal compliance by NAMCO. In terms of page 63 of his index bundle, an offer was made by NAMCO Trading to him dated 18 July 2022, subject to management approval. The NAMCO went to Enecon's home-built service stations in the military bases, and he did not know they were separate entities. The offer was to buy storage facilities designated at MOD for 53.2 million. The service stations are home-based because Enecon built them in the military bases with its own resources. They built the tanks and pumps in those service stations. It was found that all service stations in the military were not compliant with the Ministry of Mines and Energy. As such, they built new ones with Enecon resources. The old service stations were left there to be decommissioned. To recoup their investment, they were given a 15 years contract to provide fuel to MOD. The agreement with MOD is at pages 83 and 92 of the said bundle. The fuel management technology was different and not the one that was sold to NAMCO, but the right to use the pumps and tanks in MOD. Enecon changed its name from PDF. The agreement of 19 September 2012 was amended on 20 August 2013 to include construction of new home-based service stations with military consultation, subject to Enecon, then PDF, getting financial assistance in 9 military bases: Windu, Osona, Hobabis, Kietmanshoek, Walvish Bay, Oshivelo, Grootfontein, Rundu, and Oluno. The estimated cost was 43 million, but it went to 58 million. They obtained funding and constructed the service station, including pumps, tanks, canopies, petrol attendants' houses. Enecon used its own resources to build the asset. They negotiated for 53 million. NAMCO offered to buy their interest, and that is not a crime. In terms of their agreement with the military, there was no specific amount they were required to recoup. They could even get 60 million. Further, he testified that Enecon had about 2 to 3 accounts, and they would give them, in bracket, Ministry of Finance, instructions with correspondence for them to deposit in that particular account. Officials or Ministry of Finance would have made wrong or by mistake payments into their accounts. Further, the first applicant testified that until NAMCO offered, and it was their responsibility to fix the pumps and environmental issues. NAMCO offered, evaluated, and drafted the APA. He and the second applicant signed same on 15 July 2022, and the fourth applicant signed on behalf of NAMCO on 18 July 2022. They did not sell the system, the fuel management technology, but the right to use the pumps and tanks in MOD. They wanted to work on the old fuel service stations, but feared that if they opened and there were environmental issues, then they decided to construct new service stations with the ministry's consultations. It is apparent that the parties are Enecon and NAMCO Trading. As such, reference to NAMCO means NAMCO Trading unless otherwise stated. Further, he testified that the first applicant did not accuse him of fraud. The assets were built with Enecon's resources, so no one will accuse him of wrongdoing. He did not misrepresent to NAMCO. NAMCO went and verified that those service stations exist and then consciously took a decision to offer and buy the assets from Enecon. He does not understand how he misrepresented. It was up to his company and he had the right to sell those rights. Since he was conscious and truthful that the assets were built with Enecon's resources, only his company would have entered into the agreement. Paragraph 1.1 of the agreement deals with the rights, title, and interest, and they sold the rights, title, and interest. And this was different from the fuel management system. The assets refers to home-based service stations or fuel stations, he testified. They sold the rights, title, and interest in and to the assets. In the oil industry, the company that built those assets remained the title holder. Enecon built the pumps, tanks, and all underground connections, as well as petrol attendants' houses, and they remained owner until 2031. Further, the first applicant testified that the purchase price was 53.2 million. The bank account name was Enecon Bank Window account number 520. Accused 3 in bracket, the fifth applicant, NAMCO's finance executive, was a primary signatory for transparency. On count 35, he testified that he is charged in terms of section 35 in brackets A and B. The respondent did not choose either of them. He denied giving out an amount of 2.5 million as inducement or reward as per the allegations. Enecon did not pay 2.5 million, neither did he induce or reward anyone. The same explanation was given for count 36, that the respondent did not choose either section 35 subsection 3 in brackets A or B. Count 37 states offenses such as fraud, theft under false pretenses, and money laundering, which offenses do not fall under Chapter 4 of the ACC Act. He did not attempt and did not succeed, nor did he conspire with anyone. Count 39 does not talk about disguising the nature or origin of property. Count 40 was directed at him personally, but he was never personally in contract with NAMCO Trading. The contract was with Enecon and he was a director. He was never told that he was charged on behalf of the company in terms of section 332 subsection 5 of the CPA. Further, the first applicant testified that it was correct that the agreement was between Enecon and NAMCO Trading. The money from MOD meant for Enecon was to be paid to NAMCO in bank account number 520, where the fifth applicant was co-signatory. He proceeded to testify that count 40 subsection A and B was correct. In other words, both count 40 A and B were correct. Deposits were made in the said bank account. The difficulty is that if he was provided with the information about invoices, he would have explained. Further, he testified that officials made payments or wrongfully paid into any other accounts. They had other bank accounts and staff could provide other accounts other than the correct one. There is no dispute. There was an agreement before SP count 40, and that is correct. He did not commit fraud, and the agreement was between Enecon and NAMPO. Further, the fifth applicant testified that count 41 deals with section 4 in brackets B in brackets Roman 1 and Roman 2 of POCA. The amount of 213,000 was paid into Nyambali Medical Center CC in brackets Nyambali CC. He does not know the unlawful activity involved, and he was never informed such amount is part of unlawful activity. Count 42 relates to 1.5 million from Onyeka CC and falls under POC. Onyeka CC is owned by the second and third applicants, and he was just a signatory to the bank account. It was correct that NAMPO Trading procured assets for storage facilities. It was a commercial consumption in brackets transaction. He could not remember why the amount of 3.6 million was paid to Onyeka CC due to passage of time. He was a director of Enecon until 21 February 2023, about 8 to 9 months after the APA was signed. Further, the first applicant testified that we, in bracket they, used to get fuel from Total Energy, but they had volume issues and thus entered into an agreement with EcoFuel CC. EcoFuel CC and Eco Trading CC are two different entities, both owned by Victor Malima in bracket Malima. He confirmed that 35 million was paid into Enecon account number 520 on 19 July 2022, and the same amount was paid back to NAMPO Trading as agreed in account number 8,0158325. 18.2 million was paid into Enecon's bank account number 848 in terms of the APA. Further, the first applicant testified that he was never told about the 480 million. 53 million and 70 million is not 480 million. It was wrong for the state to accuse him of 480 million. With regard to the grounds of objections, he testified further that there is no way he can run away and he wants to clear his name. He has properties, people to take care of, as well as employees. He was aware about the investigations and he could have ran away. He will comply with a warning or bail with conditions and come back to the court. He will not interfere with anyone. He has 26 employees in the various business entities. The state does not have a strong case. It was a commercial transaction and he can afford bail in the amount of 20,000 Namibian dollars and will reside at F595 Hawkland Parkway. The second applicant testified that he was born in Omuntele, Oshikoto region. He has 5 children in total and 2 wives. He was arrested on 9 July 2025 at home. He received a call from his tenant in Pioneers Park that the police were looking for him. 2 hours later, more than 15 police and ACC officers came between 9:30 and 10 a.m. The third applicant went to greet them and they said they wanted to talk to both of them. The children were sleeping. The officers came and they went to sit in the sitting room. The police informed them that they were under arrest. They asked them to dress up properly and they were escorted individually to dress up. Theirs, in bracket, his right to remain silent was explained in offenses section 35, but not in detail. The police did not say the reason why they were arrested. He even asked them to wait for his lawyer, but they said there was no time to wait. He was charged on 10 July 2025, and the police just repeated the sections and asked him to comment. He asked them on what? With regard to the grounds of objection, he testified that he will not run away. He has his dignity, his family and properties. He has nowhere to run away. He never committed any offense for 52 years. He arrived on 7 July 2025 from the north, and he was 60 kilometers from Angola. He wanted, he could not come back to Windhoek. He has no fear and he wants to clear his name. He has a passport and it is with his council of record. He has no issue with bail with conditions and hand his police. He will not interfere with investigations. He will stand his trial and both his parents are deceased. Further, the second applicant testified that he has a house in the north in Onipa, Oshikoto region and 4 siblings. He has a diploma in business administration from International University of Management in brackets IUM and a certificate in business management from Stellenbosch University. He has total assets valued at 113 million Namibian dollars and the liabilities of 28.2 million dollars with net assets valued at 84.7 million. The timing of the arrest was wrong because he was on the verge of signing an agreement with an investor for an EPL worth $1 million US, about 18 million Namibian dollars. Onyeka Clearing, Forwarding and Logistics CC in brackets Onyeka CC was established in 2004 and he was a first subscriber of the CC. The third applicant became a 50% partner, but presently he has 100% membership. He was in pain because the third applicant was arrested because she is just a member and he was running or managing it. With regards to the charges, the second applicant testified as follows. Count 55, he was a director of Enecon and at the time and he never conspired. It was correct. The said amount of 3.8 million was received for clearing, forwarding and storage for fuel management technology. He was involved in both Onyeka CC and Enecon. He appeared in court. Brackets amount is not 480 million. It was incorrect that they embezzled 480 million. If he was given the opportunity by the ACC to explain, he could have done so. His continued incarceration will affect his entities. He has 26 employees and earns about 200,000 Namibian dollars. He is facing 10 charges from counts 43 to 53. On count 53, he testified that he sold rights, titles, and interest to NAMCO for 53 million. Not him personally, but Enecon. It is not correct that he sold, and he did not commit any fraud. NAMCO offered and determined the amount, and he was not involved. He was not involved in any crime. On count 44, he did not do that. He did not know that accused 8 and 3 in brackets fifth applicant abused their office, and the ACC did not tell him about the allegations. He did not offer accused 2 and the fifth applicant 2.5 million. However, he knew accused 2 and fifth applicants at the time when Enecon signed the agreement, and he had no other relationship with them. On count 45, he personally never sold to NAMCO but Enecon, but no crime was committed. He only saw the allegations when he was charged. Further, the second applicant testified on count 46 that 53 million was received by NAMCO, by Enecon, not him, and that was in terms of the APA with NAMCO. It was not proceeds of fraud, but business transaction. Enecon paid for the assets built in MOD. Count 47 does not say who is the representative of EcoFuel. The number is not given. He did not conspire, and he does not even know quality meat. Count 48 has different dates, and he never received the same amount in 2021 and 2022. On count 49, he does not know the dates and invoices, and Enecon received money from MOD in the mentioned account, and there are contradictions on the dates. On count 50, he knows the amount of 213,000 paid by Onyeka Sisi to Nyambali Sisi during COVID-19 for masks. It was not proceeds of unlawful activity, and he was a member of both Onyeka Sisi and Nyambali Sisi. Further, the second applicant testified that on count 51, the unlawful activity was not identified, and he cannot be a shareholder of Onyeka Sisi, but a member. The bank account mentioned on count 52 was not his. There is an alternative to count 53, but no count 53 itself. Section 6 in brackets 1 in brackets Roman 1 and Roman 2 does not exist in poker. He was a director of Enecon, signed the APA to sell rights, title, and interest to NAMCO. Assets refers to tanks, pumps, houses for petrol attendants, and canopies. He had nothing to do with the share valuation. Ducatus were the internal auditor that prepared the asset register as required per the agreement for its ownership of the assets. Pumps, tanks, and canopies are not movable assets. Are movable assets. The petrol attendant's house was prefabricated structure and can be moved. They were built by Enecon with its own money and had rights, title, and interest for 15 years. There was no prohibition to transfer rights, title, and interest. MOD had no issue with the incumbent assets, and there was no clause that they cannot transfer rights, title, and interest. The parties were MOD and Enecon, and a third party cannot impose terms. He also confirmed that he signed as a witness on the APA, and he was never aware of the terms of the agreement. The verification clause does not prohibit sale of assets. There was a cession agreement as EcoFuel CC had an outstanding debt with NAMCO for 70 million. Enecon took over the debt of EcoFuel CC. The second applicant testified further that why claim 53 million if 35 million of that amount was paid back to NAMCO. He reasoned that 35 million was considered legitimate, whereas 18 million was illegitimate. With regard to the grounds of objections, the second applicant testified that he cooperated with the police and he did not run away or attempt to do so. He had no intention to run away. He will comply with bail conditions. If summoned, he will come back to court. The amount of 480 million was just to strengthen the state case, and it was not true. He can afford bail of 20,000 Namibian dollars. Corruption was serious in nature, and the public needs to know, but the truth and facts from the newspaper are not correct. They were only supposed to be charged for 18 million, not 53 million, because 35 million was paid back to NAMCO. Wrong information fueled public perception, he testified. The fourth applicant testified that he resides at number 2 Hansberg Street in Glenvindu, his property, but he does not have a title deed himself. He was born in Omontele village, Oshikoto region, but he grew up in Wimby. He holds a Bachelor of Science in Chemistry and Biology, as well as an MBA from the University of Stellenbosch. He is divorced with 10 children, of which 8 are minors. He was the managing director in brackets MD of NAMCO from 2015 until he was dismissed in 2024. Further, he testified on count 1 that it relates to corruptly using position for gratification. The parties are NAMCO Trading and Enecon, a private company, not a public company, and it does not get money from NAMCO, in brackets the holding company, and has its own 3 board of directors. It is not correct that the company was a public body. He did not sign the APA as MD of NAMCO, but of the subsidiary NAMCO Trading. He was MD of both NAMCO and its subsidiaries. The offer and APA have to be read in context of the FAA. The parties to the agreement are NAMCO Trading and Enecon, a seller and buyer respectively. This was about the fuel supply between the parties and the buyer to buy exclusively from the seller. It was signed on 16 March 2022. The offer and the APA emanates from clause 4.2 of the FSA. That is the fuel supply agreement. It was factually incorrect that Enecon sold Dreams to NAMCO Trading. In compliance with the above clause, NAMCO Trading team went to inspect and verify at the various military bases. In addition to NAMCO Trading's own evaluation, they also contracted a consulting engineer for an external evaluation. Accused 4 in brackets 6 applicant wrote an internal letter to him and he approved 7. The 6th applicant was employed by NAMCO Trading and not NAMCO, the holding company. They are employees of NAMCO Trading in brackets the subsidiary and those of NAMCO, the holding company, he testified. Mr. Hashela did the project feasibility study. The APA was signed by Enecon and NAMCO Trading on 15 and 18 July 2022, respectively. The effective date was 18 July 2022, and that was in terms of clause 1.3, page 54 of Exhibit E2, which states that the effective date shall be the date on which the last party signs the agreement. Further, the fourth applicant testified that the APA does not make reference to criminal prosecution. He signed SAM in his capacity as MD of NAMCO Trading for the benefit of both parties. NAMCO Trading was to acquire assets and supply fuel to Eneco. He was not expecting a personal benefit. No one wants to be an MD of a public institution if he knows that criminal prosecution may follow. With reference to count 2, he testified that it does not make sense. He signed on behalf of NAMCO Trading and he could not pretend to NAMCO. They did not buy 9 service stations. They bought bulk fuel storage facilities or storage assets from Eneco. The assets were not owned by MOD but Eneco. If he knew, he could not have signed the agreement. On count 3, he testified that in all those business transactions, he was not acting as an agent of NAMCO, but NAMCO Trading. Further, the fourth applicant testified that he knows Malema. However, he does not own and possess such a vehicle. Malema was not a director of Enecon during the negotiation. Count 4 was factually incorrect because he did not receive any gratification for himself and the agreement was to the benefit of both parties. He did not gratify anyone and all he did was to sign SAM as MD of NAMCO Trading, and neither did he give any reward to any person. Count 5 does not make sense. On count 6, he did not agree with Malema. Count 6, he had no agreement with Malema. On count 7, he did not pretend that he had authority. If he exceeds his authority, the board has the right to discipline him. Further, he testified that the schedule of authority at page 259 of Exhibit E2 is for NAMCO, but it also relates to NAMCO Trading. NAMCO Trading was, in bracket, is a subsidiary of NAMCO, and page 256 of Exhibit E2 states that NAMCO and its subsidiaries. The MD of all companies sign and there is no limit. It does not mention the board of directors, he testified. Further, the fourth applicant testified that he was arrested on 8 July 2025 at his residence around 8:30 to 9:45. He had a meeting with someone and the investigating officer called him that he was outside and informed him to wait. He made the investigating officer outside his garage. The police referred him to several clauses of the ACC Act that he allegedly violated, telling him what he did. He was just informed 2 days later while at CI's police station. The investigating officer attempted to explain the charges, but not in detail. He asked him, what are the charges he was specifically facing, and the investigating officer mentioned some of the charges. Not in detail, but he attempted to explain, and the media was outside. He was aware about the ACC investigations through sources, and that a police docket was registered. The fourth applicant testified further he will not run away, and if he wanted, he could have run away long time ago. He had no ties outside Namibia. His roots are here. He wants to face the charges and clear his name. The charges will not stand during the trial, and he was ready to stand trial. He does not believe that the charges are strong. He has a passport and it was at home. He was willing to surrender same to the investigating officer. He was currently unemployed and survives on his last pension and he can afford bail of 10,000 Namibian dollars. With regard to public interest, he testified that when he started working at NAMCO, he had a lot of enemies and people were coming after him. There is no evidence against him, but his sin was just to work for NAMCO. He does not understand why it is not in the public interest for him to be granted bail when the case was not that strong as the media portrays it. He has no interest in investigations and will not interfere with them. He will comply and abide with bail conditions. Further, the fourth applicant testified that the APA was prepared by NAMCO Legal Department for NAMCO Trading and they purchased rights, title and interest into those assets. He does not know about the 9 service stations. The 2 entities have one legal department. Part 1 of clause 1.1 of the APA was compiled by Enecon and he could see the asset register and that was the proof before they could proceed. Page 79 of Exhibit E2 contains Enecon's asset register and that is the document about the ownership of the assets. Authored by Ducatus, confirming the correctness of the asset register. Pages 80 to 85 contains the assets. He testified that it was not in dispute that NAMCO paid 53 million in total. They could not physically take possession of the assets because they are in the army bases. In terms of clause 1.3 of the agreement, asset transfer shall be effected on 18 July 2022. From that date, they remained assets of NAMCO. The agreement persisted until such time that it was cancelled, whereafter he left NAMCO. Whether NAMCO utilized them in brackets the assets or not is another issue. Pages 86 to 88 of Exhibit E2 contains a letter from Enecon proposing to cancel the APA and refund NAMCO 53 million. Dated 17 July 2023. On 5 October 2023, NAMCO accepted cancellation and refund. Subsequently, NAMCO accepted cancellation but insisted to have the agreement remain in force. The fifth applicant testified that she was born in Kawoma in Zambia to Namibian citizens during the liberation struggle. She came back in Namibia in 1989. She resides at 49 Heckle Street, Dorado Park, Windhoek. Her property co-owned with accused 8, her husband. They have 3 children together and they were left in the hands of a nanny. They called a relative from the north to assist in taking the children to school. She is employed at Namibia Qualifications Authority in brackets NQA as head of finance and administration. She was arrested on 8 July 2025 at work. Around 11 hours by 2 female arresting officers and 1 ACC officer. She was in a management meeting and received a call that accused 2 was arrested and she called the 4th applicant to confess, but he had no knowledge at the time. The 4th applicant later called her and confirmed that it was true accused 2 was arrested. Accused 8 called her that he heard that there were warrants of arrest for NAMCO employees and she might be one of them. Further, she called and informed her supervisor if she can go home because she did not want to be arrested in the office. As she was talking to her, The secretary came and informed her that the police were looking for her. She then went with her supervisor to the parking to meet them. The police introduced themselves, Inspector Anna and her colleague and the ACC officer. Inspector Anna informed her that she was under arrest for corruption, fraud, and money laundering on matters related to NAM. She showed her a warrant of arrest with sections of the ACC Act. She also explained her right to remain silent and that whatever she said may be used against her. The officers were driving two vehicles, a sedan and a double cab. She did not evade. In fact, she went to the police. All that Inspector Anna said is that she was under arrest in terms of Section 35 of the ACC for corruption, fraud, money laundering on matters related to NAM. She was only informed in details on 9 July 2025 when Inspector Anna and ACC officers went to Glenvindu police station. The ACC explained in detail. Further, the fifth applicant testified that her highest education is a postgraduate diploma in accounting from Rhodes University in South Africa. When she was arrested, she was asked if she knew where her husband, in brackets, accused 8 was, and informed if she can take the police there so that he can take her phone and handbag. She then took the police to his workplace. Further, she was asked who was with the children, and she responded they were at home since it was holiday. They arrived, but he was not at work, and she was asked to call him. The other officer asked her who was going to take care of the children in the long run. It then dawned on her that accused 8 might be in trouble, and she also saw his name on the paper. Accused 2 came and he was arrested. The double cab was meant for him. Her handbag was given to her brother who was with accused 8. The police kept her phone and she was only allowed to call accused 8. They drove to the ACC and sat in the boardroom. Pictures were taken of her to confirm ACC arrest. She was also asked to give her phone and password to Inspector Anna, but she could not remember it as she uses face recognition. She attempted 5 times and lastly the password worked. She was also asked to switch the phone on and off using the PIN and password to prove that the PIN number was correct. Accused 8 intervened and said they needed a search warrant, and he was told that the phones are now ACC properties. Accused 8's watch was also removed. When accused 8 tried to intervene, Inspector Anna told him that he was urinating on her, and as a result, they gave the phones to her. She was told that she will be taken to Glenvindu police station. Further, the 5th applicant testified that on the way to Glenvindu station, the 2nd officer requested to stop at Windu station because they wanted to see number 1 in person, for they have not seen him in person. She asked who is number 1, but they did not respond. She asked again. The 2nd officer nodded to confirm that number 1 was the 4th applicant. The 2 officers left her with the ACC driver, who asked them whether it was correct to leave a suspect in the vehicle, and they responded that the vehicle had child lock. Thereafter, they proceeded to claim Windhoek Station. Upon arrival, Inspector Anna told her welcome home, and she responded that that was not her home. She was handed over to officers at the station. She has assets as depicted in Exhibit E2 with a total value of 4,250,000. She also runs a tuck shop business employing 2 female persons on a permanent basis, and it generates 18 to 20,000 Namibian dollars per month. But at the moment it was closed because she was in custody. Her ties are in Namibia and her parents are pensioners. Her passport with her cancel of record, and she has no objection if same is provided to court. Her employment contract with NAMCO is on page 30 of Exhibit E2 as Executive of Finance and Administration, responsible for financial management of both the holding company NAMCO and its 2 subsidiaries, NAMCO Exploration and Production Pty Limited and NAMCO Trading and Distribution Pty Limited, in brackets NAMCO Trading. Further, the 5th applicant testified that she was not involved in the APA. She confirmed that she was a signatory to account number 520, opened in October 2021 by the directors of Enecon. The effective date for her to be a signatory was 16 March 2022, when the FSA was signed to protect the interests of NAMCO. When Enecon entered into the FSA, one of the conditions was that if money comes from MOD for the supply of petroleum products purchased from NAMCO, Enecon should pay the money to NAMCO to ensure that funds are not used for any other purpose. The control measure was that a signatory from NAMCO be put on that account. Immediately when Enecon transferred money into that account, it was immediately paid to NAMCO, and Exhibit B1 reflects such payments. She testified that starting from 6 July 2022 to 21 October 2022, she counted on her own in total 10,224,198 Namibian dollars 81 cents paid to NAMCO. She has demonstrated that every time the account was credited, the money was debited to NAMCO. The only transaction was 35 million, but she has demonstrated 10.2 million paid to NAMCO. NAMCO was paid and evidence is before court. The statement that they were giving fuel for free was false and misleading. Enecon paid, and that means that Enecon account number 520 for NAMCO was received money, for NAMCO Trading received money. The money was coming from Enecon's main account number 848. If the money was paid into into account number 848 by Ministry of Finance, it was then paid to account number 520. The purpose of Enecon resolution dated 26 October 2021 is that Enecon board resolved that she can be added as a signatory. On NAMCO's side, the effective date was 16 March 2022, and she could not transact before that date. And she had no authority. The APA was a product of the 16 March 2022 agreement to protect NAMCO's interests. She had no access to account number 848 4.9 million was paid into account number 520 on 20 January 2022, and at that time she was not a signatory to the said account. Further, the fifth applicant testified that she was a NAMCO employee and taking care of the subsidiaries. With regard to financial matter, there is a financial statement for NAMCO and another for NAMCO Trading. Payments to account number 520 goes to NAMCO Trading, she testified. NAMCO receives levies from National Energy Fund in brackets NEF, and that is allocated to NAMCO for administrative and payment of expenditures. NAMCO Trading receives no money from the levy given to NAMCO. NAMCO Trading operates independently, generates its own income predominantly from the sale of petroleum products, and pays its own expenditure and debt. NAMCO administratively supports NAMCO Trading, she testified. The finance function is in NAMCO. However, there are teams supporting NAMCO Trading. Her evidence was that NAMCO accountant is allocated to NAMCO Trading, paid for by NAMCO, the holding company. With regard to charges, the fifth applicant testified as follows. On count 20, she does not conclude, sign or negotiate FSA with resellers or sit in such meeting. She was not part, she is, in bracket, was part of the credit committee that authorizes credit policy. Clause 5.9 of the credit policy gives her authority to give credit to customers. Clause 6 deals with the composition of the credit agreement. Clause 6 deals with the composition of the credit committee. Each customer has a credit limit, and it can be 5 million, 50 million, or 100 million. Customers can request credit above 15 million. Clause 8 allows credit above 15 million. In terms of clause 5.8, the practice was that customers have 30 days to pay. That is why they allowed customers to exceed the limit. Herself, the executive of downstream supply and logistics, in brackets accused 2, and the fourth applicant will take all credit decisions. The composition of the credit committee was herself as chairperson, accused 2 and 6 applicant, among others. Further, she testified that Panduleni CC was paid 1,450,000. She did not receive any money from Eneco, Irongo, Petroleum CC, or Oshali CC personnel. She was not a member of Panduleni CC, and she had no role to play in the affairs of the CC. There was no money transferred to her personal bank account. Panduleni CC, there was no money transferred to her personal bank account. She does not know the owner of Quality Meat CC. She was aware of the payments from Panduleni CC to their mortgage bond, and she did some payments, and that is their house. She was aware that there has been payments from Quality Meat CC to Panduleni CC and was a co-signatory to the latest bank account in her capacity as the wife to accused 8 in order to attend to any payments as needed for farming activities. She was not aware about anything else other than farming activities. On count 21, she made payments and she was authorized, she testified. As executive of finance, supporting documents were brought before payments were made. On the payments of 53.2 million, she had the following documents. One, the request prepared by the sixth applicant, signed by the fourth applicant as MD, stating that NAMPO has made budgetary provision for 25 million and 40 million for business development as approved by the board for the acquisition of the assets. The budget for NAMCO includes budget for the two subsidiaries, and this validated the payment. 2. Asset evaluation report. The internal memo which highlighted existence and value of the assets. In fact, another report contained the pictures and signatures of contained the pictures and signage of Enecon prepared by Mr. Shafeni, who is not before court. 53.2 million was paid. 3. Independent asset evaluation report by Seal Engineering confirming the assets and the value was higher than that which they paid. 4. Fixed asset register in brackets FAR submitted with a letter from the accountant of Enecon. Ducatus confirming the correctness of the FAR. 5. The feasibility study by Mr. Sam Hashel. 6. APA. She had it before authorizing the payment and it was signed by the fourth applicant as MD. Clause 2 or 3 of the APA states that 35 million to be paid to NAMCO, and she went through the agreement between Enecon and MOD, and there was no incubable asset. The FAR was evidence that the assets belong to Enecon because the accountant will not recognize assets that do not exist without economic benefits and value. Further, the fifth applicant testified that she did not misrepresent nor did she pretend to anyone based on the information she presented to the court. Further, when authorized signatories make payments as a control measure for NAMCO, there are two independent signatories that release the payments. If the payment is above $1 million, 2A signatories, meaning two executives duly authorized, must approve the payment. The check requisition for 19 July 2022 had supporting document. She checked and approved Sam, and it was approved by two persons. There is a preparer of the payment, the assistant accountant. It is then checked by the financial accountant and then the finance manager. It is then checked by herself and the finance executive and approved by two signatories, herself and another. The board has two independent signatories, independent from finance. She authorized payment into Enecon's account and then passed Sam to Mr. Sheffield. She cannot say why only her, because it was approved by 4 people who signed it. There was no unauthorized except the reallocation. The fourth applicant was duly authorized to enter into agreement both for the holding company and subsidiary, and his authority as far as entering into agreements has no limit. 53 million was paid and the fourth applicant was duly authorized. All documents were authorized and she was authorized to release the payment. Even when she released the payment, she was duly authorized as an A signatory. On count 23, she testified that the statement that she had access to Enecon's bank account from 26 October 2021 was totally not correct. Was technically not correct. The account was opened on 26 October 2021 The purpose of Enecon board resolution was that she can be added as signatory. It only gave us authority when the FSA was signed on 16 March 2022. At the time, she had no authority only on 16 March 2022. The allegations is false. Clause 3.1.1 gave her the authority. There was a session between NAMCO Trading, Enecon, and EcoFuel CC. She highlighted three things: registration 2000/421, and that there was a board resolution that the MD was duly authorized effective 2 March 2022. EcoFuel CC owed NAMCO Trading 73.3 million Namibian dollars. And there was a board approval. The charge sheet states 70 million, and there was a board resolution for payment arrangements in the amount of 500,000. There were payments from Enecon to NAMCO. That is why there is a difference from 73 million to 70 million. The date 2 March 2022 was not correct, and the date was taken over on that date. That agreement was approved by the board. The date did not accumulate between 2 March 2022 to 2 December 2022, but it was taken over on 2 March 2022, she testified. Further, the fifth applicant testified that Irongo Petroleum CC's bank account is 8019151399. She highlighted the credit committee authority at page 308, stating that they have to understand the liquidity, the solvency and efficiency of the customer when making the decision. It was her evidence that the policy does not dictate credit limit, but the committee based on the customer's needs. The policy was silent on how much to give. However, if the limit was above 500 million, the MD must approve. Yes, there was a limit, a credit limit for Irongo Petroleum CC and approval. They are allowed to exceed the credit limit. The committee dictates and the policy is silent. She noted payment from Irongo Petroleum CC amounting to 7.3 million on 5 and 29 July 2022. She also observed payment from August 2022 until April 2023 and testified that Irongo Petroleum CC was paying until she left and when the fourth applicant was suspended. As such, they could not have caused the financial loss. It is what happened after the interim management came in, she testified. As far as they know, the account was out of credit limit and Irongo Petroleum was paying, but paying on a monthly basis. Irongo Petroleum was buying but paying on a monthly basis. It was false that they were giving Irongo Petroleum fuel for free. She disagreed that the respondent has a strong case. The charges are baseless, contains inaccuracies, timelines when they were not at now. On count 24, she did not receive any money from Enecon. She was only a signatory to Panduleni CC, and the said CC has no limitations to trade. Panduleni CC did not transfer any money into her personal account. On count 25, she was not at NAMPO in May 2023, and she did not conspire with anyone. 53 million was not paid into her personal bank account. Now, with regard to public interest, in brackets, with regard to public policy, in bracket, interest, the fifth applicant testified that the public was smart enough to see what was transpiring here, in brackets, in court. Their, in brackets, applicant's story did not change. They acted within their mandate of credit policy and were duly authorized. Where they made mistakes, the contract of employment says disciplinary hearing, not prosecution. The fourth applicant told her in 2024 that a police case was open and she knew that they could be called or arrested. She did not try to run away, and she will not run away because this was done in the ordinary course of business. It was not in the public interest to keep a mother with 3 minor children in custody. Since she left NAMPO, she has moved on and has no interest to interfere with witnesses or investigation. Documents are on the record, she testified. Finally, she testified that she can afford bail in the amount of 10,000 Namibian dollars. Her passport was with her counsel of record, and she has no issue with reporting convictions. Now, as stated above, the 6th and 7th applicants brought their bail applications by way of affidavit, and same forms part of the record as exhibits F and G. The 6th applicant stated in her affidavit that she is ordinarily resident at number 17 Northern Valley Ambrose Street, Clenecupe Window. She is currently unemployed and unmarried. She occasionally conducts consultancy services for various individuals, including juristic persons. She is a mother of a 24-year-old male presently studying in Spain. All her relatives are in Namibia, and she has no assets outside Namibia. She owns a motor vehicle and an immovable property, in bracket, flat, registered in the name of a closed corporation known as Abentier Street Properties CC, of which she holds 100% members' interest. She is amenable to surrender her travel documents to the investigating officer, and she undertakes not to apply for new travel documents. She can afford bail in the amount of 10,000 Namibian dollars with conditions. Further, the 6th applicant stated in her affidavit that she was arrested on 8 July 2025 at around 17:19. In other words, 19 past 1700 hours. She received a call from a certain Inspector Anna, who identified herself as a police officer and informed her that she wanted to drop an envelope with her, and she was with the ACC official. She was then requested to come to Clen Window Station, which she did. Upon arrival, she was informed that she was under arrest. She requested to call her legal representative, but she was informed that her colleagues were already arrested and her legal rights were explained without more. She was informed about her reasons for arrest, which was because of fraud and money laundering, without any further details about the allegations. She was allowed to make a call to arrange for a motor vehicle to be collected, and thereafter Inspector Anna demanded her cell phone, the PIN and password. She also asked whether that was legal, but she was informed that both her and her property were now state properties. Her request to call her legal representative was denied. Further, she stated that she was aware about the investigations, and she had all the time to flee if she wanted, or if she had such intention. With regard to the charges, the 6th applicant stated in her affidavit that she will tender a plea of not guilty at the trial to all the charges leveled against her. The state believes that they have a strong case against her, but it is a weak one. It has been established that the so-called serious charges can best be described as being chaotic, poor, and absolutely shambolic. For the following reasons: she was an employee of NAMCO Trading and not NAMCO, as the state alleges. She had no authority to increase any credit limit, and certainly she increased no credit limit as alleged. She joined NAMCO Trading during October 2019, and at that point, Eco Fuel was already conducting business with NAMCO Trading. She denies that she corruptly used any public office for gratification, and that in any event she occupied no public office. She is also aware about the sale. She is also unaware about the sale of 9 service stations, but there was an APA between NAMCO Trading concerning the rights, title, and interest to assets owned by Eneco. The transaction was foreshadowed by the FSA. She was tasked by Davis Mofaso Mofaso to prepare the internal memorandum dated 8 July 2022 after considering the report and financial feasibility study prepared by Mr. Shafeni and Mr. Hashela. She was convinced the said documents made a good business case and supported the transaction. In any event, the memorandum was simply a recommendation, she stated. Further, the 6th applicant stated in her affidavit that she had never conspired with any of her co-accused, or anybody for that matter. The state failed to specify the person to whom she may have misrepresented. She confirmed at paragraph 2.7 of her affidavit payment from an entity known as Venus Technology CC on 4 August 2022 in the amount of 10,000 Namibian dollars. The payment was not for any moment in respect of any NAMCO Trading or NAMCO related matter. The payment was made in respect of consultation she did in relation to a feasibility study for an intended medical center. Further, she stated in her affidavit that she was advised not to deal with the merits of the charges at this stage of the proceedings. The allegations lacked substance and factual basis. The presumption of the law is that she was innocent until proven guilty in a competent court, and she cannot be kept in custody as a form of anticipatory punishment. Further, she stated that she is not a flight risk. On her first appearance, it was submitted that investigations in this matter were finalized. This blows apart the state's ground of objection that they will interfere with investigations. It was imaginary and unsubstantiated for the state to fear that she will interfere with investigation. She is unaware of who the state witnesses are. Further, the 6th applicant stated that she did not endanger the safety of the public or commit any offense. She has no intention to abscond, and she will not interfere. She will not, influence any person or destroy any evidence, and neither will she undermine the criminal justice system. Further, she stated that she does not dispute the seriousness of the charges. However, she was advised that the charges at this stage is simply a label and not conclusive of anything. She is presumed innocent until proven guilty in a competent court of law. Section 61 of the CPA only find application in respect of any offenses referred to in Part 4 of the schedule. She will stand her trial and not abscond. Finally, she stated that her release is in the interest of justice and that she has proven that exceptional circumstances exist justifying her release on bail. The seventh applicant stated in his affidavit that he is residing at F4834 extension 24 on Dangwa, which is owned by his cousin. He was born in Anamulunga village, Oshikoto region. He has a valid passport and is currently in the possession of his council of record. He is a qualified plumber by profession. He has no relatives and assets outside Namibia. He is a father of a 9-year-old child, and he is responsible for her upkeep. He is self-employed as a plumber, earning about 10,000 Namibian dollars. He can afford bail of 5,000 Namibian dollars. He does not own any immovable property, but he is in the process of constructing one at Onamulunga village. He has no pending case or previous conviction. His ties are in Namibia. Further, he stated that he was arrested on 10 July 2025. He received a phone call from the ACC investigators requesting to meet them at Ondangwa, which he did, and he was arrested. With regard to the charges, the seventh applicant stated in his affidavit that he is charged with 2 counts. However, it became apparent that during submissions, his counsel of record confirmed that he was charged with 3 counts. He denies the allegations against him and he intends to plead not guilty to the charges during the trial. He stated further that he was advised not to deal with the merits of the charges at this stage of the proceeding. However, he deemed it appropriate to deal with the merits. He stated that at some time towards the end of 2019 or beginning of 2020, Austin approached him with an idea of registering a petroleum company. Resultantly, a close corporation named Petroleum Irongo CC in brackets Irongo CC, with its principal business being the supply of all petroleum products, import and export, and transportation, was registered. On registration of Irongo Petroleum CC on 13 February 2020, he held 40% membership interest. Saima Emmanuel in brackets Saima, 40% membership interest, and Matthews Panduleni Iyambo in brackets Iyambo, 20% interest. On 23 November 2020, The amended statement indicates that he held 70% membership interest, whereas Iyambo and Christina Ndafenengo, in brackets Ndafenengo, held 15% membership interest each. Paragraphs 38 and 39 of his affidavit reflects that on 14 May 2022 and 27 October 2023, he held 100% membership interest. On 13 November 2023, he held 30% and Austin 70% membership interest. On 15 February 2024, Austin held 100% membership interest. Further, he stated that Iyambo and Ndafenengo ceased to be members of Irongo Petroleum CC on 27 October 2023. He stated further that at paragraph 44 that during the period December 2022 until May 2023, the members and authorized signatories of the bank accounts were himself, Iyambo, and Ndafenengo. The state's allegation that he was 100% shareholder was factually incorrect. Further, the seventh applicant stated that during his tenure as member of Irongo Petroleum CC, he played no role in the operations of the business, apart from signing documents that required the signature of the members. The operations of the business were attended to by Austin, and members would sign special powers of attorney which enable Austin to deal with lawful aspects of the business. The specified power of attorney granted Austin broad authority to act on behalf of Irongo Petroleum CC as depicted on paragraph 48 of his affidavit. One such power of attorney was signed on 27 June 2022 by himself, Saima, and Iyambo. Even though he was a signatory to the bank account, he had no access to such bank accounts, as such access and power was granted solely to Austin, nor did he have online banking access. Therefore, he could not have made payment of $500,000 on 17 December 2022 to Quality Meat CC in terms of count 60. He does not know who made such payment, and it appeared to be an electronic fund transfer. He denies making such payment both in his personal capacity and on behalf of Irongo Petroleum CC. Further, he stated that the state does not have a prima facie case against him. Count 61 was more worrisome as it lacked material allegations, such as to whom the misrepresentation was exactly made. Based on the statements provided by the state, Irongo Petroleum CC made payments to NAMCO of about 93.6 million on his count. Therefore, the state does not have a strong case against him. Irongo Petroleum CC and NAMCO Trading had an FSA. Further, the seventh applicant reiterated that at no point did he interfere with investigation, and the identity of the witnesses and suspects are unknown to him. The case against him is very weak. He will not endanger the public and will not attempt to evade, and neither will he attempt to influence, intimidate, or destroy any evidence. He will abide by bail condition. Now the respondent's case. From the onset of the proceeding, the respondent disclosed his ground of objection to the release of the applicant on bail as follows. 1. Risk of abscondment. 2. Fear of interference with witnesses and host investigation. 3. Seriousness and strength of the state's case. And 4. Not in the public interest or interest of the administration of justice that the applicant should be granted bail. The investigating officer testified that he is employed by the ACC. He started working for the Namibian police (NAMPOL) in 2000 for 8 years until March 2009. Thereafter, he joined the ACC for the first time as an investigating officer until 2012. He joined Standard Bank Namibia from 2012 to 2020 as a manager for forensic investigations. In November 2020, again joined the ACC as the Chief Investigating Officer to this date. He is the investigating officer in this matter. It all started, he testified, on 7 February 2024 when he was assigned to investigate an anonymous complaint reported to the ACC that accused two may be involved in corrupt practices. For he was depositing large sums of cash in his bank account. He was then assigned as the investigating officer to look into the allegation. The ECC also received a case docket, Windhoek CR 379/04/2024, referred from NAMPOL. Ironically, accused 2 was also listed as a suspect in that docket, which was different from the anonymous complaint. Further, the investigating officer testified that there were too many allegations in the docket. Firstly, that NAMPO staffs accused 2, 5th and 6th applicants and procedurally, without following NAMPO procedures, supplied petroleum products to Enecon and Irongo Petroleum, CC. Further, it was alleged that the supply took place between 1 August 2022 and 4 May 2023, and the value involved at that time was 277 million, rounded off. Secondly, it was alleged that the 4th applicant had corruptly and fraudulently abused his office and position as MD of NAMCO, and he entered into an APA with Enecon and on 18 July 2022 without having followed internal policies of NAMCO, including the procurement policy. The 4th applicant failed to follow the financial, procurement and budget policies in that he acquired or attempted to acquire the fuel storage facilities (assets) from Enecon to the value of 53.2 million. The complainant in this docket was Mr. Engelhard Kongoro, the then NAMCO board member and chairperson of the Finance and Audit Committee, a subcommittee of the board responsible for NAMCO Trading, a subsidiary of NAMCO Holding. The complaint was reported after an internal investigation was concluded by NAMCO, after it was anonymously reported during April 2023 that NAMCO had acquired the assets, but they were not known to the board. The investigating officer testified that the investigations were done jointly with NAMPOL, to which the ACC was the lead investigator, and he was assigned to investigate the two cases together. Further, the investigating officer testified that on 19 November 2021, Enecon provided a credit guarantee of 5 million to NAMCO, and that was the beginning of the relationship between the two. As part of NAMCO's credit policy, when a customer applies for a credit facility, a credit guarantee is undertaken by NAMCO to mitigate losses. A credit guarantee serves as collateral provided by the customer, and if the customer defaults, NAMCO can then recall the guarantee to reduce exposure of the losses. Further, he testified that after the 5 million guarantee was granted, Enecon was given a credit limit of 5 million, which was equivalent to the credit guarantee provided by Enecon to NAMCO at the time. However, the credit guarantee was short-lived and it was cancelled on 29 November 2021. Evidence indicates that the credit guarantee was cancelled by the fifth applicant as there was something wrong with the guarantee and he was not sure what was wrong. Subsequently, the credit guarantee to Enecon was zeroized, meaning that if Enecon needed petroleum products, they had to pay cash. That was the case from 15 December 2021 until 2 March 2022, when EcoFuel CC ceded all its debts and liabilities to NAMCO to the value of 73 million. There was a resolution attached dated 2 March 2022 by Enecon in which it was resolved to take over the liabilities of EcoFuel CC. One of the resolutions was that Enecon would negotiate for the exclusive fuel supply with NAMCO, which was done on 16 March 2022 when Enecon entered into an FSA with NAMCO. And they were provided with a credit limit of 15.2 million. The directors of Enecon at the time were the first and second applicants, as well as James V. Awala. Further, the investigating officer testified that it was important to mention that when Enecon was given a credit limit of 15.2 million, they did not provide a credit guarantee of the same amount. It was agreed in terms of the FSA that Enecon would use government purchase orders as a guarantee. All purchase orders issued by Enecon to NAMCO would be accompanied by the government purchase orders issued by MOD. Failure to include government purchase orders meant there will be no petroleum products to be issued to Enecon. This was a safety mechanism for both parties, and more so since there was no credit guarantee by Enecon, and it was to protect NAMCO from fuel losses. Further, one of the conditions was that the fifth applicant would be granted access to Enecon's account number 520, which was also serving as another level of security so as to ensure that money is deposited, once money is deposited by MOD, a role was to debit Enecon and credit NAMCO's bank account. The investigating officer testified that interestingly, when they obtained the account statement of Enecon, it was opened on 26 October 2021, which was before the commencement of the relationship between Enecon and NAMCO. The resolution of Enecon dated 26 October 2021 was used, in which the fifth applicant was granted access to the new bank account. The resolution did not indicate why the fifth applicant was granted access to the said bank account, and this was done at least 5 months before the FSA between Enecon and NAMCO. There was no authorization from NAMCO authorizing the fifth applicant to be a signatory to Enecon's bank account. Further, the investigating officer testified that Enecon became a customer of NAMCO. They had a debt of 73 million, seeded by EcoFuel CC. And Enecon was then given a credit limit of 15.5 million, which meant that they could take petroleum products from 0 to 15.5 million. The earliest evidence, 10 May 2022, 2 months after signing the FSA, NAMCO was planning to acquire the fuel storage facilities. The fourth applicant authorized Mr. Michael Aipanda and Shefeni from Engineering and Technical Services to visit the 9 military bases to conduct an evaluation of the assets that NAMCO intended to buy from 11 to 19 May 2022. Subsequently, the 2 staff members visited the sites accompanied by Enecon employee Mateus Iyam. An evaluation report of the assets was produced. There was also a verification of the evaluation of the technical team by SEAL Consulting, and there was a difference in the values of the 2 reports. The technical team valued the assets as 53.2 million and SEAL Consulting at 54 million. In addition, there was a discounted cash flow report by Hashela on the instructions or request of accused 2 and 6 applicants to make projections whether the undertaking was commercially viable, dated 6 July 2022. Further, he testified that, interestingly, between 16 March 2022, when Enecon entered into the FSA with NAMCO, until July, their debt rose to 35 million, almost 20 million above the limit without a credit guarantee. The investigating officer testified further that following the discounted cash flow report, the 6 applicants wrote an internal memorandum dated 8 July 2022 motivating NAMCO, in brackets, NAMCO Trading, to acquire the assets. The submission was submitted by Maposa and accused 2, accompanied by recommended by Sefeni and approved by the 4th applicant. Following the approval of the 6th applicant submission, a commercial offer was made by the 4th applicant on the even date 8 July 2022 to Enecon, and it was subsequently accepted by the shareholders, in bracket directors of Enecon, the 1st and 2nd applicants. The commercial offer was made by the 4th applicant and the MD of NAMCO and its subsidiaries. The commercial offer to Enecon was very specific. NAMCO wanted to buy assets valued at 53.2 million, and the nature of the assets was described in the same commercial offer, which was accepted by Enecon. After the offer was accepted, a contract was prepared by NAMCO's legal team. No other procurement process was done. The contract was signed by Enecon's directors on 15 July 2022 and fourth applicant signed on 18 July 2022. Interestingly, he testified there was an instruction as far as the payment of the 53.2 million was concerned to be paid into separate transactions. 35 million to be paid into bank account number 520 and the 18.2 million to be paid into bank account 848. Bank account number 520 was the one where the fifth applicant had access, and the amount was to be paid to Enecon's outstanding debt to NAMCO of 35 million. Accused 2 was on the same date. The agreement was signed by Enecon's directors, paid 150,000 Namibian dollars from Erongo Petroleum CC via Quality Meat into his personal bank account at Standard Bank. At the time this transaction was made, Erongo Petroleum CC was 100% owned by the seventh applicant. Quality Meat CC membership interest since inception was held by Hileni Itana, in brackets Hileni 100%. They visited the given address of Quality Meat CC because they thought it was a butchery, but there was no butchery. It was only a residential area. A residential address at 38 Fumbe Street, Mbambasia. BIPA documents indicates that the beneficial owner was Malima. Quality Meat CC's bank account. Quality Meat CC's Windhoek bank account signatory is Malima, who is out of the country. Investigations are ongoing. Further, the investigating officer testified that after the APA was signed by the fourth applicant on 18 July 2022, no procedures for procurement and budget were complied with. On 19 July 2022, at about 09:17 a.m., the invoice of 53.2 million was sent to the fifth applicant by Rebecca Erasmus from Enecon, and she sent the same to accused 2 and 6 applicant by email to certify same. It was also sent to Martha Shikongo, in brackets Martha, by the fifth applicant with instructions for her to initiate the process. Subsequently, accused 2 certified the invoice for the purchase of the assets in respect of the payment, and Mafosa certified same on behalf of the 6th applicant as she was not in the office. The assets were encumbered to MOD by agreement signed on 15 September 2006 under correction, he testified. Part of the investigation was to verify the allegations, and they visited MOD. First, they had to verify the agreement between Eneken and MOD on the supply of fuel, and secondly, the purchase orders issued by MOD in favor of Enecon and invoices received by MOD from Enecon from 1 August 2022 to December 2022. The investigations established that indeed there was a 15 years agreement, and the allegations were confirmed that there was an FSA between Enecon and MOD ending in 2031, and it was still in force at the time. The investigating officer testified further that it was evident through investigations that Enecon did not tell MOD that they were selling the assets sold to NAMCO, which assets were situated on military bases. Further, the agreement stated that the assets will become MOD assets by 2031. MOD only became aware that after the minister inquired from the executive director (ED) after learning about a civil case in the High Court. MOD tried to seek clarity from August 26, an entity owned by MOD. Further, the investigating officer testified that interestingly, these were the very assets sold by Enecon to NAMCO. In actual fact, from 19 July 2022, when payment was made to April 2023, when the fourth applicant was suspended. The acquisition of the assets was unknown to the board or in fact to the entire NAMCO, as it was only reported anonymously in April 2023. When NAMCO board became aware that NAMCO Trading acquired these assets, despite the acquisition of the assets, it was business as usual as Enecon continued to supply fuel to MOD despite the sale of the assets on 18 July 2022. He testified that until today, NAMCO has never received or enjoyed any benefit for having acquired these assets, and a question can be asked, why were these assets sold to NAMCO in the first place? He testified. On 19 July 2022, after the invoice was certified, 2 transactions were made as stated to earlier, 35 million Namibian dollars into bank account 520 and 18.2 million into bank account 848. As per the agreement, the 35 million was paid back to NAMCO to offset the debt of 35 million incurred by NAMCO following the FSA of 16 March 2022. Enecon only had a credit limit of 15.5 million in terms of the FSA. By 19 July 2022, they had exceeded the credit limit and the debt stood at 35 million. 73 million was ceded by EcoFuel CC to Enecon, and the total exposure in terms of value stood at 108 million. Further, the investigating officer testified that immediately after payment was received by Enecon, 3,613,000 was paid on the same date into a bank account of Onyeka CC owned by the second applicant and accused 7, or then third applicant, 50% membership interest each. From that amount, the first and second applicants were paid 1.5 million each into their personal bank account held at bank value. The signatories of Onyeka CZ are both the first and second applicants, as well as accused number 8, in brackets, third applicant. Further, the investigating officer testified that 9.5 million was paid by Enecon to to Eco Trading CC, which is 100% owned by Malima, and these funds was disbursed to various entities. On 20 July 2022, $1,040,000 was paid to Parkwood Petroleum CC, which is 100% owned by accused 2, who at the time was still employed by NAMCO as manager of supply and logistics. This was the same money paid by his employer NAMCO at the time. $1,470,000 Namibian was paid to Bank Windhoek account of Quality Meat owned by Helene, to which Malima is the beneficial owner and signatory of the bank account. Further, the investigating officer testified that when the money was received by Quality Meat CC, immediately an amount of 960,000 Namibian dollars was paid to accused 2's personal bank account held at Bank Windhoek. This was the very money paid from NAMCO to Enecon, Eco Trading and Quality Meat CC, and ended up in accused 2's personal bank account. Of the remaining balance of 510,000 Namibian dollars into Quality Meat bank account CC, 500,000 was paid into Panduleni CC, which is 100% owned by accused 8, who is also the husband to the 5th applicant, who was at the time the executive for finance and administration at NAMCO. In order for the 53.2 million to leave the bank account of NAMCO, it was approved by the 5th applicant, he testified. Further, the investigating officer testified that 1.5 million was paid to Eco Trading, that 1.5 million paid from Eco Trading to Eco Fuel CC. Eco Fuel CC is owned by Johanna Amunjeko and Martha Aintindi. The amount was withdrawn in cash in 2 parts on 20 July 2022, 700,000 and 800,000 by Connie van Wyk, accused 10. The signatories to the specific bank account into which the money was paid were Austin, that is accused 11, and accused 10. The addresses for Eco Fuel and Eco Trading are number 15 Hammerskorp Street, which happens to be the address for the first applicant. 2 additional payments were made by Enecon to Onyeka CC of 200,000 in total between 19 and 25 July 2022, which resulted in Onyeka receiving 3.8 million Namibian dollars from Enecon in total. An amount of 213,000 Namibian dollars was paid by Onyeka CC to Nyambali CC, which is owned 48% each by the first and second applicants, and the remaining 2% by a certain Adele. Of the above amount of 212,000 Namibian dollars was paid to Development Bank of Namibia in brackets DBN. The signatory to Nyambali CC are the first and second applicants. On 20 July 2022, 1 million, part of the money from NAMCO, was paid to Venus Technology CC, which is 100% owned by Austin. Part of this money, 10,000 Namibian dollars, was paid by Venus Technology CC into a savings bank account of the 6th applicant in August 2022. Further, there were cash deposits added to the said amount in brackets in Venus Technology CC bank account and that money was used to deposit a vehicle in 1,184,000 Namibian dollars used to pay a deposit on a vehicle bought by Austin. The vehicle changed ownership and investigations are ongoing at the moment, he testified. Further, 1.2 million was received by Eco Trading and it was paid to Oshali Fuel Investments, CC, in bracket Oshali Fuel CC, owned by Simeon Haingela Nangolo. The said amount was subsequently paid to NAMCO by Oshali Fuel CC. Further, the investigating officer testified that having looked at how the funds received from NAMCO was distributed, taking into consideration that NAMCO bought assets which they never used from 18 July 2022 to date, it was concluded that the APA was simply a vehicle or instrument that was used to enable the money to be paid from NAMCO Trading. NAMCO had the opportunity, and so did the fourth applicant from 19 July 2022 when funds were paid until he was suspended, but did nothing. Evidence indicates that some of those funds went into the pockets of staff members and or indirectly to relatives or husband of the fifth applicant. If one adds the amount of 960,000 Namibian dollars received into the personal account of accused 2 and 1,040,000 Namibian dollars paid into an entity which is 100% owned by him, it means that accused 2 received gratification of at least 2 million Namibian dollars, he testified. Accused 2 was instrumental in the acquisition of the assets bought by his employer. He recommended the submissions for NAMCO Trading to acquire the assets, and together with the 6th applicant, they arranged and instructed Hashela to compile the discounted cash flow report. These activities were done in their official capacity, yet ended up receiving gratification from the same entity. Further, the investigating officer testified that similarly, the 5th applicant approved the payment in her official capacity, following which 500,000 Namibian dollars was paid to Panduleni CC, which is held 100% by accused 2, by accused 8. An amount of 646,000 Namibian dollars was paid into the home loan of the 5th applicant and accused 8 from the money received from NAMCO Trading. Further, the investigating officer testified that investigations revealed there was misrepresentation by the 2nd and 3rd applicants in that they did not disclose that NAMCO could never take ownership of the assets that NAMCO was buying, because when the commercial offer was made on 15 July 2022 in brackets 18 July 2022, NAMCO Trading specified what they wanted to buy. Before Enecon accepted the offer, they had the opportunity to change or indicate that they were not selling, or NAMCO Trading could not buy the assets as per the offer. Similarly, even on 15 July, when they signed the agreement, they had the opportunity to specify what exactly they were offering to NAMCO Trading, which was not recovered to this date. Excuse me, but that I'm going to take it again. Similarly, even on 15 July, when they signed the agreement, they had the opportunity to specify what exactly they were offering to NAMCO Trading, but that was not done. That caused NAMCO Trading to suffer losses of 53.2 million, which was not recovered to this date. Further, the investigating officer testified Enecon did not sell anything to NAMCO to this date. Enecon used part of the 53.2 million to offset the date. Basically, it paid NAMCO's debt with NAMCO's money in his own way. NAMCO never took ownership of any assets, he testified. This was enabled by the fourth applicant in the sense that he bypassed all procedures to have that contract signed. If NAMCO Trading never took ownership of the asset they intended to buy, there was no urgency in not having followed the procedures, he testified. He testified further that the fourth applicant was well aware about the acquisition from the time they started planning to buy the assets in May 2020 until he was suspended in April 2023. The fourth applicant failed to report the acquisition of the assets to the board. The investigating officer testified further that evidence has shown that there was conspiracy, meaning there was a plan between Enecon, in bracket the first and second applicants, as directors who accepted and signed the offer together with the fourth, fifth, sixth applicants and accused two. Hence, they did not do anything from the time the APA was signed until the matter was reported anonymously to the former Ministry of Finance, Mr. Shimi, who brought it to the board's attention. He testified further that nothing was done because NAMCO Trading entered into an agreement to buy assets which they did not use or own, and it was business as usual by Enecon, supplying fuel to MOD using the same assets they sold to NAMCO Trading. Partial analysis of all accounts was done, and that is how the ACC was able to conclude that there were corrupt practices, despite the Enecon's account being zeroized and 35 million was paid to NAMCO. I'm going to take it again. Partial analysis of all accounts was done, and this was how the ACC was able to conclude that there were corrupt practices. Despite Enecon's account being zeroized, 35 million was paid to NAMCO. Between 1 August 2022 to end of November 2022, Enecon's debt rose to 35.7 million again. He testified further that Mr. Kongoro's statement that the amount was 277 million, of which 38 million was alleged to be Enecon's fuel debt. During investigation, they went back to NAMCO and they requested records and invoices in respect of the two entities, Enecon and Irongo Petroleum CC. The investigation officer testified that NAMCO Trading was able to provide the investigation team with invoices totaling 35.7 million from 1 August 2022 to November 2022. These invoices were issued to NAMCO Trading regarding fuel supplied to Enecon. Upon reconciliation, that is why they have different figures from those reported by Mr. Kongoro. The invoices were accompanied by respective purchase orders issued by Enecon to Namco Trading and comprised of email approvals by members of the credit committee, the 5th and 6th applicants, as well as accused too. The investigating officer also noted that the condition that when Enecon issues purchase orders to Namco Trading for fuel supply, such order should be accompanied by the corresponding purchase orders issued by MOD. They could not find any corresponding purchase orders issued by MOD to Enecon as per the agreement in custody of Namco Trading, meaning that fuel supply was contrary to the agreement because the agreement clearly stated that the FSA, that failure to issue corresponding purchase orders means no fuel would be supplied to Enecon. However, they have evidence that fuels were supplied to Enecon despite there being no purchase orders from MOD. The investigating officer testified further that the investigation team proceeded back to MOD in order to obtain evidence of the purchase orders issued by MOD for fuel supply to Enecon from 1 August 2022 to November 2022. The rationale was that one of the conditions in the FSA was that all invoices issued by Enecon to MOD should have bank account number 520. The purchase orders and invoices for the said period were obtained from MOD. Evidence showed that the invoices were issued by Enecon for that period to MOD using a different bank account, 848, which was contrary to the FSA conditions. The agreement was that invoices must have account number 520, which was a misrepresentation because the money would not have gone into the intended bank account. Further, the investigating officer testified that in order for the payment to be processed through a purchase order, there is a verification process by the government to curb incidences of fraud. There are markers and checkers within the finance tree. Part of this balance and checks is to verify that the money is paid to the account number listed on the invoice by the service provider. What it means is that an entity can have 2 or 3 listed accounts by the Ministry of Finance, and payment would be made to an account listed on the specific invoice at the time. He testified that it was noted during investigations that despite Enecon having incurred debts of 35 million as a result of the FSA signed on 16 March 2022 and taking into account that there was no credit guarantee provided by Enecon, it looked like Namco Trading through its credit committee members in brackets accused 2, 5th and 6th applicants allowed fuel supply from 1 August 2022 to end of November. Further, the investigating officer testified that in fact Enecon has already demonstrated their inability to honor their debt. Namco suffered prejudice of 35 million, accused 2, fifth and sixth applicants failed to comply with internal policies when they authorized the credit for the supply of fuel to Enecon by NAMCO Trading. NAMCO Credit Committee had other members such as the head of legal, the manager for finance and the accountant. As such, any request should have come to the full credit committee. Although the other three members were not decision makers, they would have made recommendations either to approve or disapprove, and such was not done. The decision makers were accused 2, 5th and 6th applicants. The credit limit was sanctioned when a customer was onboarded to allow such a customer to receive products to a certain amount without payment. With regard to Irongo Petroleum CC, the investigating officer testified that part of the complaint received was that fuel was supplied to Irongo Petroleum CC, an entity at the time owned 100% by the 7th applicant. The transactions reported were from December 2022 to May 2023. Irongo Petroleum CC received petroleum products from NAMCO Trading as per the agreement signed on 20 September 2022. Investigations revealed that at the time, Irongo Petroleum CC was given credit of 3 million Namibian dollars, and in November 2021, they applied to increase the credit limit. 10 million was approved. 2 credit guarantees were submitted, one for 6 million and another for 4 million, making the total of 10 million, meaning that NAMCO Trading could supply fuel for 10 million without prejudice because the guarantee was sufficient. The investigating officer testified further that, however, the credit guarantee for 4 million Namibian dollars was recalled, but the credit limit remained the same at 10 million Namibian dollars. Evidence showed that Irongo Petroleum's profile from 20 December 2020 to November 2022 was good. Between December 2022 to May 2022, the account balance was 238 million. This means that NAMCO Trading supplied fuel at 238 million, for which little payments were made. When the ACC started investigating NAMCO investigations, NAMCO Trading had demanded the guarantee for 6 million, and the total exposure to NAMCO Trading was 238 million. That is 238 million minus 6 million comes to 238 million. Further investigations established that the approval process was similar to that of Enecon, where accused 2, 5th and 6th applicants approved fuel above the credit limit. Evidence further established that there were payments made to 3 credit committee members by Irongo Petroleum when they were the people actually approving fuel supply to such an extent. Further, the investigating officer testified that between 27 May 2022, multiple transactions totaling 950,000 were made into the bank account of Panduleni CC, owned by accused 8. Interestingly was the transaction of 500,000 made on 17 December 2022 by Irongo Petroleum CC through Quality Meat to Panduleni CC. It was his evidence that it was interesting because on 14 December 2022, the fifth applicant approved a purchase order in favor of Irongo Petroleum CC where they received fuel valued at over 22 million. The investigations concluded that this was the result of the fuel approval by the fifth applicant. Similarly, accused 2 also received 1.6 million under correction as he testified from Irongo Petroleum through Quality Meat CC. The payments originated out of Irongo Petroleum CC between 15 July when he first received 150,000 Namibian dollars. The amount of 1.6 million comprises various transactions made between 15 July 2022 and November 2022. Further, there was an amount of 10,000 Namibian dollars paid during the first or second week of August 2022 to the sixth applicant by Austin. Although Irongo Petroleum CC was at the time 100% owned by the seventh applicant, there was a power of attorney authorizing Austin to make business transactions. The fourth applicant was suspended somewhere in April 2023 because of a number of internal investigations by NAMCO, and one of those related to fuel supply to Enecon and Irongo Petroleum CC, he testified. NAMCO placed a moratorium on further supply to the two entities. Fuel supply to Irongo stopped in November 2022. Despite the moratorium, the fifth and sixth applicants further authorized fuel to Irongo Petroleum CC. Further, the investigating officer testified that evidence shows that the fifth and sixth applicants were questioned about fuel authorization. The sixth applicant was not happy and she left and went to work for Irongo Petroleum CC. As they were busy with investigations, they received intelligence that a vehicle was bought by Malema for the fourth applicant. Evidence indicates that the vehicle was bought from Audi Center Windhoek in 2023 and it was over 3 million Namibian dollars. A deposit of over 900,000 Namibian dollars was paid and he could still get the date and precise amount of the deposit, he testified. Sources provided photos of the vehicle the fourth applicant have been using it, and he personally saw the fourth applicant using it last year. They looked at the NATIS registration of the vehicle and they found out that it was registered under Helene. Further, investigation revealed that Helene is a cousin of the first applicant and in fact the namesake of the first applicant's mother. They contacted her and she confirmed that she does not own such vehicle. In February 2025, they visited Audi Center and there were records that the fourth applicant has taken it for service. The vehicle is part and parcel of the ACC investigations, and the reason is due to the relationship between NAMCO and Malema. The relationship started in July 2018 when EcoFuel CC entered into a fuel supply agreement with NAMCO Trading. EcoFuel CC was owned by Johanna Antindi and another in 2020 at the time, and currently by Malema, who is also 100% beneficial owner. EcoFuel CC agreement resulted in the debt of 73 million being ceded to Iran to Enecon, on 2 March 2022. Malima is 100% beneficial owner of Eco Trading CC, Quality Meat CC, and Oshali Fuel. All these entities are recipients of funds that were originally paid by NAMCO Trading for the acquisition of the assets from NAMCO. Further, the investigating officer testified that from the 18.2 million paid by NAMCO Trading to Enecon, Eco Trading received 9.5 million on 19 July 2022. It is apparent from the record that at this point, Mr. Namanje, on record for the first and second applicants, stated that the applicants have no issue if Mr. Lilongwe can lead his witness because most of the payments are common cause and not in dispute. Mr. Namanje continued that a number of witnesses have testified confirming those payments, including the investigating officer. The investigating officer confirmed that Exhibit B4 indicates that Quality Meat CC received $1,470,000 Namibian dollars from Eco Trading and $500,000 Namibian dollars was paid to Panduleni CC on 20 July 2022 and $960,000 Namibian dollars was paid to accused two's personal bank account on 21 July 2022. On 21 July 2022. On 26 July 2022, $350,000 Namibian dollars was paid to accused two from Irongo Petroleum CC. The investigating officer testified further that Exhibit B5 reflects that Onyeka CC received $3,613,000 Namibian dollars on 19 July 2022, and the first and second applicants each were paid $1.5 million on the same day. Exhibit B9, the first applicant's bank account reflects that he received 1.5 million Namibian dollars as management fee. Exhibit B10, the second applicant's bank account also reflects that he received 1.5 million as management fee on the same day. The amounts were part of the $3,613,000 Namibian dollars paid to Onyeka CC, and it ended up in their personal bank account. Exhibit B6 is the bank account of Panduleni CC and reflects that Quality Meat CC made the following payments: 500,000, 100,000, another 100,000, and 500,000 on 20 July, 5 and 26 October, as well as 17 December 2022, respectively. The investigating officer testified further that Exhibit F reflects that Irongo Petroleum paid 10,000 Namibian dollars to the sixth applicant on 4 August 2025. They are looking at gratification. Fraud was a serious offense and it was committed while executing her duty. Further, the investigating officer testified that he was present when the second applicant was arrested. NAMPOL executed the warrant of arrest on both the second applicant and third applicant. Their legal rights and charges were explained. When they were charged, he was present and explained the charges. The sixth applicant's appointment is part of the evidence. Whether she was employed by NAMCO or NAMCO Trading, this was about her conduct, he testified. On paragraph 2.2 of the sixth applicant's affidavit, He testified that there was documentary evidence that she approved the fuel supply to Irongo Petroleum CC and Enecon. On paragraph 22.3, the investigating officer testified that NAMCO Trading is a subsidiary of NAMCO, and he could not say whether NAMCO Trading is a public entity. However, gratification does not matter whether a person is a public or private institution. On paragraph 22.4, he testified that the sixth applicant initiated this submission dated 8 July 2022. On paragraph 22.5, the investigating officer testified that conspiracy started when the planning for the acquisition of the fuel storage facility started. The 10,000 Namibian dollar paid to the six applicants' bank account was gratification, which was directly or indirectly. There was a strong case against her, even if it was commercial transaction originally. The subsequent action makes it a crime. It was clear that the moment the matter came in terms of the APA, it was distributed to various entities held by the staff and their relatives. With regard to the seventh applicant, the investigating officer testified that evidence established that he held 100% interest in Irongo Petroleum CC. Irongo Petroleum CC entered into an FSA signed by seventh and fourth applicant. Irongo Petroleum received petroleum products of 238 million, and he believed that they have a strong case. He believed further that he was in agreement he testified further that he was in agreement that the normal course commercial contract would be, in the normal course, a commercial contract would be civil. The problem is that funds were being paid to staff members who authorized fuel to Irongo Petroleum CC subsequently. With regard to paragraph 67 of the affidavit, he testified that he knew that the seventh applicant has a valid passport, but he did not know its whereabouts. Paragraph 68, he testified that it was correct that he presented himself to the regional office. However, he proceeded that he was not aware that he was going to be arrested. The investigating officer testified that the first applicant was one of the people who went to their office with his lawyer. The sixth applicant also brought herself to Windhoek Station, but she did not know that she was going to be arrested. With regard to paragraph 72 and 73 of the seventh applicant's affidavit, he testified that they have sufficient evidence that he was involved and his entity received 238 million. He was 100% owner. However, he could not confirm that he was involved administratively. With regard to the grounds of objection, in particular interference with investigation, the investigating officer testified that the charges are serious and involves money laundering. They believe if the seventh applicant is granted bail, he will interfere. Fraud is a Schedule 2 offense. Money laundering and contravening ACC Act. On paragraph 46, he testified that both entities, Enecon, EcoFuel CC, Irongo Fuel CC, and Onyeka CC, Quality Meat CC, and Irongo CC and Venas CC relationship was interconnected. Although the entities are registered by different persons, they are branches of the same tree. With regard to risk of abscondment, in particular on the first applicant, he testified that the risk is there. The charges are fraud, conspiracy, money laundering, and he has the means in terms of funding. With regard to interference, he testified that this case was very complicated. This case involves complicated investigations, and there was very high degree of interference by the first applicant. On the aspect of public interest, it is evidence that he was of the belief that the public is concerned with economic offenses due to significant impact on the economy and goes to how the world views Namibia. With regard to the second applicant, he testified that the risk of interference with investigations and witnesses is there. On the issue of abscondment, he testified that investigations established that the second applicant lived in Dubai. As such, the risk of interference was there and the charges are serious. With regard to the fourth applicant, he testified that while the vehicle is not there, which was a sign of interference and the risk of interference is there. The charges are serious and involves fraud, money laundering, corruption, and have serious penalty. There is public interest, and he was the MD. Namco suffered actual prejudice. On the fifth applicant, he testified that due to the seriousness of the charges, the likelihood of interference with investigation is there, given that she has been arrested, and if granted bail, she can interfere. With regard to the sixth applicant, he testified that some witnesses approached to obtain evidence are afraid, and the possibility of interference is there. The value involved in this matter is not small. Overall, the investigating officer testified that due to the seriousness of the charges, the risk of interference with investigations and witnesses exists. However, a number of suspects are still to be arrested. One suspect is on the run, and there is a likelihood of interference. The charges are complicated, and a number of assets were procured. Investigations are still ongoing, hence the fear of interference. Submissions by both parties. Submissions on behalf of the applicants. Written submissions by both counsels were handed into the record and form part of the record. As such, this court will not regurgitate same, but will only highlight when necessary. It is apparent that hotly contested submissions were made by both counsels. Further, it is also apparent from both submissions and opening statement that the applicants had no qualms with their arrest and detention, but the issue according to them was whether the arrest was necessary. It was submitted by Mr. Namanje on behalf of the first and second applicants that only one or two charges refer to section 332 in bracket 5 of the CPA. The state opted to charge his clients personally. Mr. Namanje submitted that if you don't rely on section 332 in bracket 5 of the CPA, a director cannot be held personally liable. It was submitted further that it was a commercial transaction, not a commercial. It was a commercial transaction and not a criminal matter. Further, it was submitted by Mr. Namanje that they have proved that the first and second applicants are good candidates for bail, and bail be granted in the amount of 50,000 Namibian dollars with conditions. Mr. Bangamabo, on behalf of the fourth and fifth applicant, submitted that the applicants appears in a case termed the Fuelrot. However, there was no such thing as Fuelrot, but just sensation. He submitted that the first applicant was charged for pretending to have authority. However, the investigating officer testified that he had authority even up to 500 million. There were no bank statements presented for his clients, and neither did they receive any money. There was no criminal prosecution. There was no criminal prosecution for failure to comply with internal policy. The investigating officer testified that the vehicle in question was owned by Delaney, not the fourth applicant. Mr. Bangamabo submitted further that the investigating officer testified that he never met the first applicant, but it was further his testimony that he also followed him. But he retracted his evidence, as such his evidence should be approached with caution. And finally, it was submitted by Mr. Bangamabo that the fifth applicant's crime is that money was paid into an entity 100% owned by the eighth applicant, and that the applicants have proved to be good candidates for bail in the amount of 50,000 Namibian dollars be granted. Mr. Casper, on behalf of the six applicants, submitted that the investigating officer's answer in cross-examination is final. He cannot retract. Further submitted that public opinion should not be disregarded lightly. The ACC is a champion in fighting corruption and should be commended for the job because it's not an easy one due to public perception. However, that comes with inherent dangers because public opinion is not always informed by reason and it is not sound. The applicants are innocent until proven guilty, and that despite his strong case and seriousness, bail was granted to the other accused. That's the Amshelelo case, placed the Amshelelo case on reliance. Further, he submitted that 50,000 Namibian dollars be granted to his client. Mrs. Gebhardt, on behalf of the seventh applicant, submitted that the court must lean in favor of granting bail. The seriousness of the offense lies in the sentence to be followed. The accused must not be kept in custody as a form of anticipatory punishment. Further, Ms. Gebhardt submitted that she was aware that the state would argue that her client brought bail by affidavit and that he was not cross-examined. He submitted that there was no factual dispute between the investigating officer's evidence and her client, that on the question of bail, the evidence of the investigating officer properly viewed supported her client's application for bail. The seventh applicant had contact with the suspect Malima before arrest. It was further submitted by Mrs. Gebhardt that the investigating officer contradicted himself in that her client had 100% membership interest in Irongo Petroleum CC from December 2022 to 2023, that the investigating officer ignored the PIPA amended documents of 2023. In a bold move, Mrs. Gebhardt invited the court to make an extempore judgment if so inclined and grant her client bail and reasons to follow later to avoid further prejudice. Now, it is opportune to state at this point that clearly the court declined such invite, and it will become apparent in due course why. Mr. Lilungwe, on behalf of the applicant, on behalf of the respondent, submitted that Amshelelo case was distinguishable from the present and that the respondent should be commended for granting bail for the two accused persons because they carefully considered the evidence and circumstances of the case. The state applied its mind and further that the starting point with regard to an application for bail is that proof is for bail is that proof is on a balance of probabilities, not beyond reasonable doubt. Reliance was placed on S versus Yogen case. And finally, it was submitted by Mr. Lilongwe that bail should be refused in respect of the applicants. Now, the applicable legal principle. In S versus Penero, the court will not repeat the full citations on record because the citations are provided in the judgment. The court cited with approval a passage from Detroit et al. In commentary on the Criminal Procedure Act as follows. In the exercise of its discretion to grant or refuse bail, the court does in principle address only one all-embracing issue: will the interest of justice be prejudiced if the accused is granted bail? And in this context, it must be borne in mind that if an accused is refused bail in circumstances where he will stand his trial, the interests of justice are prejudiced. Four subsidiary questions arise. If released on bail, will the accused stand his trial? Will he interfere with state witnesses or police investigation? Will he commit further crime? Will his release be prejudicial to the administration of justice, law and order, and security of state? At the same time, the court should determine whether any objections to release of the applicant can be curbed by suitable bail conditions. In Shekunga versus States, Sibaya AJ, as it then was held as follows. Bail applications are neither civil nor criminal proceedings, are sui generis and unique in nature, procedure and purpose. The use of affidavits in applying for bail without viva voce evidence is allowed as it is part of our law and it is therefore endorsed. Further, the court cited with approval the decision in the Constitutional Court of South Africa in S versus Ndlamini, S versus Glandler, S versus Jobert, and S versus Shikat, where the court described bail in paragraph 11 as follows. Furthermore, a bail hearing is a unique judicial function. It is obvious that the peculiar requirements of a bail as an intellectually and inherently urgent step were kept in mind when the statute was drafted. Although it is intended to be a formal court procedure, it is considerably less formal than a trial, so the evidential material proffered need not comply with the strict rules of oral or written evidence. Also, although bail, like the trial, is essentially adversarial, the inquisitorial power of the presiding officer are greater. An important point to note here should be bail proceeding is so self-evident that is often overlooked is that there is a fundamental difference between the object of bail proceeding and that of a trial. In a bail application, the inquiry is not really concerned with the question of guilt. That is the task of the trial court. The court hearing the bail application is concerned with the question of possible guilty only to the extent that it may bear on whether the interests of justice lie in regard to bail. The focus on the bail stage is to decide whether the interests of justice permit the release of the applicant on bail. In Chizu versus S. Liebenberg J. as he then was held that the proper approach in deciding the risk of interference with state witnesses or investigations is to ask whether it is likely that the appellant will not may interfere. In the Cleric versus the State at paragraph 18, it was held as follows. In order to curb the serious escalations of crime and the escalations of accused persons evading the course of justice by absconding, the legislature gave the court wider powers and additional powers to refuse bail in cases involving serious crime by amending Section 61 of the Criminal Procedure Act 51 of 1977. The said section provides as follows. If an accused who is in custody in respect of any offense referred to in Part 4 of Schedule 2 applies under Section 60 to be released on bail in respect of such offense, the court may, notwithstanding that it certified that it's unlikely that the accused, if released on bail, will abscond or interfere with any witnesses for the prosecution or with police investigation, refuse the application for bail if, in the opinion of the court, after such an inquiry as it deems necessary, it's in the interest of the administration of justice that the accused be retained in custody pending his or her trial. Now, it is tried law that a bail application may take any of the three processes, namely ex parte statements made by counsels from the bar, by filing affidavits and viva voce evidence. It is desirable that the applicant and the state should provide evidence to support their respective contentions. Obviously, an accused will have an affidavit will have less probative value than viva voce evidence, which is subject to the test of cross-examination. At the same time, an affidavit will carry more weight than a mere statement from the bar. Further, it is tried law that in a bail application, the applicant bears the onus to prove on a balance of probabilities. The applicant must prove on a balance of probabilities that he or she is a worthy candidate of being granted bail, and that the interest of the administration of justice will not be prejudiced. If he or she is granted bail, the applicant or accused must specifically make out his or her own case and not necessarily rely on the perceived strengths or weaknesses of the state's case. However, this does not mean that the state is relieved of a duty to lead evidence in support of its objection to the release of the applicant or applicants on bail. Both parties in the bail application are under obligation to place factual materials before court to assist it in balancing the two competing interests and arrive at a fair and just decision to both parties. The accused, in brackets, applicants, are innocent until proven guilty. In a competent court of law, bail is not anticipated. paid the mortgage bond of the property co-owned by the fifth applicant and accused aid. Further, the speed at which these payments were made also raises more questions. In other words, on the same date, 19 July 2020, when 53.2 million Namibian dollars was paid, NAMCO to buy NAMCO. Part of that money was and subsequently landed into some of the applicants, accused persons, or suspects, business entities, as well as accounts. In particular, on the event date, 3.6 million was paid to Onyeka CC, and subsequently to the first and second was paid to Irongo, and subsequently 470,000 to CC, 160,000 was paid to Panduleni CC and accused 2 on 20 July 2022. Panduleni CC was paid, Irongo Petroleum paid 350,000 to Quality Meat on 26 July 2022, and on the even date, the same amount was paid to accused 2. Irongo Petroleum paid 10,000 Namibian dollars to Venus Technology on 4 July 2022, and on the even date, the same amount was paid to the 6th applicant. Irongo Petroleum also paid 500,000 to Quality Meat on 17 July 2022, and on the even date, the same amount was paid to Panduleni CC. As stated above, the payments to some of the applicants accused 2 and 8, as well as entities in which the whole interests are not in dispute. It was submitted by Mr. Namanje during evidence in chief of the investigating officer that the applicants have no issue with the payment and such on costs. However, the applicants raise issue that this was a commercial transaction and does not call for criminal. According to them, it should have been settled in a commercial court or as per the contract. It was submitted by Mr. Namanje further in reliance to the respondent's submission that the applicant stated on face value that it was a commercial transaction. Mr. Lilungwe, on the other hand, for the respondent, submitted that a single action may give rise to both criminal and that the state or respondent was not precluded from pursuing both criminal and civil liability. I pause to observe that the issue of a commercial transaction goes to the merit of the case, and it appears to this court that that issue is at the heart of the applicant's defense. Accordingly, it is an issue to be determined at the trial. It may or may not be a commercial transaction. Hence, the veracity of the totality of the evidence would not ordinarily beg consideration at this stage of to determine the strengths or the weakness of the state case. It is also common cause that anyone sold the rights, title, and interest in and to those assets for 53.2 million to NAMCO Trading. The said APA was signed by the Enecon and the 4th applicant on 15 and 18 July respectively. NAMCO Trading paid the full amount on 19 July 2022. Further, as per the agreement, the amount 35 million was paid back to NAMCO. The investigating officer correctly testified that Enecon used part of the 53.2 million to offset the debt. Basically, it paid Enecon's debt with NAMCO's money. Therefore, the assertion that Enecon paid NAMCO Trading's debt using the latter's money holds true, because that money came from NAMCO Trading and it was paid back to NAMCO on the same day. Further, the second and third applicants testified that Enecon was the owner of the assets and they remained owner until 2031 because they were built. Examination by Mr. Ilongwe. The first applicant testified that Enecon built the assets on the basis of the agreement with MOD because they were granted 15 years to recoup their investment, and throughout that period, those assets, those service stations, in brackets, assets, even now belong to Enecon, and that is the practice in the oil industry. Whereas the second applicant testified during cross-examination by Mr. Ilongwe that they were having the rights, title, and interest in those assets. That is what they sold. During cross-examination, it was put to the first applicant by Mr. Ilongwe, whose service station are those. He testified that they belong to MOD. We left those service stations and built new ones, new service station with the equipment and the resources of Enecon. It was put to him that the state was not concerned with those that were commissioned. He testified that they sold title and assets that they put in and the MOD was aware that those assets belong to Enecon. When asked that earlier, he testified that they belong to MOD and now to Enecon. Which one was correct? An objection was raised by Mr. Guy on behalf of the record for the second applicant, and after Becken, the first applicant that those service, when they entered into the agreement, belonged to Enecon. It is apparent from the record that Mr. Ilongwe never referred to the old assets, to the old service stations, by the new one built by Enecon inside the first testified belonged to MOD and later they belong to Enecon. Also apparent in testified during this examination by Mr. Ilongwe that NAMCO was entitled and the right to use the facilities built by Enecon. He proceeded enjoyed was to be an exclusive supplier of the MOD. However, it is apparent NAMCO bought the not the right to use or to be exclusive supplier in terms of the APA. The FSA and the APA were two different agreements. Later was the purchase of the assets, fuel supply. Asked where you, the second applicant testified he did not know Mrs. Hinderman ownership, considered that they were having both the first and second applicant conceded that when the APA was concluded in September 2016 was still in force. It is also apparent from the record that both the first and second applicant testified that NAMCO Trading did not take ownership of the assets because they cancelled the agreement. During cross-examination, it was put to the first applicant by Mr. Ilongwe